This courtroom moment starts with a DWI case that looks simple at first, but quickly becomes much bigger. Mr. Martinez is in a Harris County courtroom in Houston, Texas, and the state has to prove more than just drinking before driving. They have to show he was actually intoxicated, either through his physical or mental condition or a blood alcohol level of 0.08 or higher. Without that proof, the case starts to weaken fast. The prosecutor finishes questioning the officer, and on paper he looks prepared. He has the badge, the report, the training, and the confidence. But then the defense attorney stands up, and this is where the hearing takes a turn.
Mr. Flood, you ready?
I'm sorry, did the state pass?
State pass witness.
All right. Yes, I'm ready to see where to begin. You saw the video that we all watched of you approaching Mr. Martinez, right?
Yes, sir.
And despite your insistence on, well, you told the jury that you asked him how much he had to drink, or if he had been drinking, right? That he admitted he had.
Yes, sir.
It's not illegal to drink alcohol and then drive if you're not intoxicated, right?
Correct.
Are you a drinker?
No, sir.
You don't drink any alcohol?
No, sir.
Okay. Do you think everybody that drinks alcohol and then drives is guilty of DWI?
No, sir.
So you said you were out that night as a speed to look for speeders.
It was traffic enforcement. Yes, sir.
I think you said you were out there looking for speeders
Yes, sir.
and also drunk drivers.
Yes, sir.
So you were like the speeding and drunk driving enforcer that night.
Correct.
Are you familiar with the saying that when you're a hammer, everything looks like a nail?
Sure.
So that was kind of your role that night. You were out there looking for, it was the night shift.
Yes,
You're
sir.
looking for people to arrest or pull over for DWI, right?
Correct.
And you happen to find someone who looked like a nail. He was speeding, and you smelled an odor of alcohol, right?
Yes, sir.
Now, you wrote an office report in this case, correct?
Yes, sir.
And you wrote that close in time to when this happened, right?
Correct.
You bring a copy of that with you?
Yes, sir.
I saw you kind of looking down earlier. It's okay to refresh your memory because I know it was a little time ago, but can I just ask you, you don't read directly from it
Correct.
word for word. If you say, hey, do you mind if I refresh my memory? That's fine, okay?
Okay.
You stated that you smelled an odor of alcohol on his breath.
Yes, sir.
And that was when the state was asking you questions right here.
Mm-hmm.
You didn't say I smelled a strong odor of alcohol.
Correct.
You didn't say I smelled heavy odor of alcohol. You just said I smelled an odor of alcohol.
Okay.
Right?
Yes, sir.
You could have said, when they said, what did you smell? You could have said, I smelled a strong or heavy odor of alcohol on his breath, right?
That's correct.
But you did not say that.
That's correct.
But you'd agree with me anyway, though, that just having the odor of alcohol on your breath, that doesn't prove a person's intoxicated.
That's correct.
Everybody knows that, right?
Yes, sir.
It doesn't even tell you how much alcohol a person has consumed, right?
That's correct.
Even if you said a strong odor of alcohol, that doesn't mean that, well, that person's really consumed a ton of alcohol, right?
Correct.
Okay. So he admitted to drinking. You smelled the odor of alcohol. That makes sense, right?
Yes, sir.
Okay. Him drinking and him admitting to it and you smelling it, that doesn't mean he was intoxicated, though, right?
That's correct.
Okay. I don't know I'm 53. My hearing's not what it used to be, but he didn't say I had several. We didn't hear that. Are you telling the jury that that's what you heard? How old are you?
I'm 50.
Do you wear hearing aids?
No, sir.
Do you have trouble hearing? Has any of your family?
In a closed room, yes.
Okay. Family members ever said something like that? Like they have to me? You have to repeat themselves?
But sometimes.
After listening to it, I think once or twice, are you still trying to, you're under oath here, right?
Yes, sir.
And you're still telling these folks here that we all heard that he said, I had several drinks? Or do you want to change that answer now? Just tell us the truth. He never said several drinks. They got this man charged with a criminal offense. You understand that?
Mm-hmm.
If you were charged or a family member, would you want an officer up there not telling the truth to a jury?
Well,
Objection,
no,
Your Honor.
No, sir.
No, sir. Is that your answer?
Yes, sir.
So why is it okay for you to do that? You said it wasn't the truth.
No, I never said that, sir.
Did he say several drinks?
He said a few, yes.
Did he say, I had several drinks? Like you testified to under oath 2 times.
Yeah, that's an answer, Judge. Overruled.
Which is it? Because you just said, no, he didn't say that.
No, he said few.
Is that fair to exaggerate facts or to tell the jury things that are not true?
No, because a few means several.
He never said several. He never said a few. You know, you play it again? I'll play it as many times as you want. Can you, if I played it again, can you point out to the jury where he said I had a few drinks? Officer, look, I'm not trying to trick you. This is important. We want to be fair, right?
Yes, sir.
We want to be fair. Your job's too important to not tell the truth under oath, isn't it?
That's correct.
I mean, is it that important that you've got to exaggerate and make up things that aren't true just to try to convict this guy?
No, I'm not trying to convict nobody.
Well, then why aren't you telling the truth to the jury? We all heard it.
The video showed the truth.
Right. The video shows the truth.
Yes, sir.
You asked him if he had been drinking.
Yes, sir.
He said a little bit.
We can go back and see the video.
Really? It's not important to you? Did you watch the video before testifying?
Yes, I did.
I just wanted to be clear about what happened. And we have the video, and then we have what you're saying the video said. Those don't match up, do they? Yes or no? Is what you told the jury match up with what is on the video?
Yes.
How is that okay? That's not okay. You went up to him and you asked him, have you been drinking? And he said a little bit, right? I will play the video again. It's in evidence. Do I need to, or will you just agree with me that that's the truth? Because if you're not going to agree with me that that's the truth, you want me to play it again?
Sure.
You guys mind? Help us drive.
Your Honor, for the record, that's State's Exhibit 2 at the 2-minute, 34-second mark.
What's going on? Where you coming from? Oh, nothing. Oh, did you guys get the drinking cup? Little bit?
You stop right there. You said, how much did he have to drink? Have you had anything to drink? What did he say?
A little bit.
A little bit. He didn't say a few, correct?
Correct.
He did not say several, correct? Okay. So that's not a part of this case.
Correct.
Go ahead. Thank you.
Pause right here, because this is not just a normal courtroom exchange. This is where the defense starts attacking the officer's credibility piece by piece. The attorney is not arguing with feelings. He is using the officer's own words against him. What he said in court, what the video shows, and what he wrote in the report are not lining up. And that matters, because once the jury sees one clear inconsistency, they may start questioning everything else. From what is shown, the officer told the jury Martinez admitted to several drinks. But the video says something different. The report says something different again. Now, there are 3 versions coming from the same witness. And the next part is where the case becomes even more intense.
You came back to the vehicle. You asked him again, how much have you had to drink tonight? And he said, 1. And you said, are you sure? He said, yeah. He didn't say a few, right? He never said several, correct?
Correct.
Is there anywhere else on the video that he said a few or several?
No, there's a part of the video where it says obviously, yeah.
I'm sorry?
There's a part of the video where he says honestly,
He said,
yes. Honestly, yes.
yeah.
Or yeah.
Well, that's why I wanted to show you what the state showed you. And the answers that you gave don't match up with what Mr. Martinez said, right?
Correct.
We heard you ask him 2 times about drinking. Did he ever say he had a few or several?
No, sir.
But why would you come to court under oath and tell the jury that? Why? That's may I approach the witness, Your Honor? I've got copies of your offense report.
Yes, sir.
I'd like to show them to you. I don't know what you have, but you wrote in your offense report, right, that you asked the driver if he had any alcoholic beverages, right? We heard that. That's the whole purpose of that on body cam, right? We see the truth. That's the truth.
Right.
Not what you're saying. Right? Right?
Yes, sir. Right.
And he stated, what did you write? He had only 1, and you put O-N-E, and then you put parentheses and the number 1 in there to make sure that there was no confusion in your office report that he said he had 1 drink.
Yes.
You never wrote anywhere that he had a few or several or that he came back later and said, well, honestly, I have more to drink. Is that anywhere in there?
No, sir.
Is this the kind of police work that you are used to getting away with doing?
No,
Oh, so you don't get away with this all the time?
no.
Or you do get away with it all the time?
No.
Yes or no? Do you get away with it?
Objection relevant.
It's move on.
On the back, you write again that you asked the driver if he had any alcoholic beverages. That's like 2 places. And he stated that he had only one.
Yes, sir.
And you wrote the number 1, O-N-E,
Yes.
and then you put parentheses,
No.
the number 1. Anything about that I misrepresented?
No, sir.
You approached the vehicle and he was holding his license and insurance out the window.
Yes, sir. Correct.
You were going to ask him for that, right?
Yes, sir.
How in the world is that a sign of intoxication? You said he was bouncing it?
Yes, sir.
That's a sign of intoxication.
Usually drivers.
Is that a sign of intoxication?
No,
Yes
sir.
or no?
No,
Then why are you here trying to tell the jury that it is?
I never said that.
Do you remember 10 minutes ago when they were asking you questions and you said he was bouncing his license and you're trying to insinuate that that was weird or some,
That was an observation.
right, about like his mental or physical faculties?
Yes, sir.
So, okay. You talked about NHTSA, right?
Yes, sir.
I know this isn't the manual you received, but National Highway Traffic Safety Administration, that's NHTSA, right?
Yes, sir.
That's an acronym that stands for the federal agency that is the authoritative body on how to administer field sobriety tests, right?
Correct.
And they give you an arsenal of 3 tools, 3 tests. There's an eye test, the horizontal gaze nystagmus, right?
Yes, sir.
You know the name of the other 2?
Yes. One good turn, one extent.
Okay. 3 tests that you can use to administer, and as you said, to determine if a person is intoxicated or not, right?
Yes, sir.
And that's what you were intending to do. You smelled alcohol. You asked him if he would do those sobriety tests,
Yes, sir.
and he said no. People have the right to refuse those tests, right?
Correct.
And he invoked that right. He thought about it. He made a conscious decision and said no, right?
Yes, sir.
Which he has the right to do.
Yes, sir.
Now, what you decide to do if somebody refuses, that's up to you, right?
Yes. The National
Correct.
Highway Traffic.
It's up to you. Objection, that's non-responsive, Your Honor. I asked a yes or no question.
Both of you guys are, it's just, don't get hostile. Ask the question, let him answer it. That's it.
Objection, non-responsive.
What's your question?
I said if he refuses or submits, if he refuses, what you decide to do next is up to you.
Yes, sir.
Okay. So you intended to perform those tests, as you stated, to determine if he was intoxicated or not, right?
Correct.
But you were not able to perform those tests to determine if he was intoxicated or not, correct? You stated that. So in your training, you went through. You received a manual about the standardized field sobriety test, right?
Yes, sir.
And that talks about the history of alcohol in the country, administration of the field sobriety tests, but also a whole list, a litany of signs about how a person's driving that could also indicate intoxication, right?
Yes, sir.
I mean, there's 100 different clues they list that say if a person is driving like this, that could mean they're intoxicated.
Correct.
Did you know that speeding has never been one of those signs?
This is speed.
Speeding. Did you know that speeding has never been listed as one of those signs?
It says speed and braking.
Is everybody that's speeding intoxicated?
No, sir.
Only at night
No,
when you're out there looking for drunk drivers.
I'm not looking for anyone.
Well, that's not what you said earlier, is it? You said you were out there looking for speeders and drunk drivers.
No, I was still traffic enforcement.
Mr. Martinez, there's no evidence that he was swerving, correct?
No, sir.
You didn't testify to that, right?
No, sir.
You testified to everything you observed about his driving to the jury,
Yes, sir.
which would indicate that you thought he might be intoxicated, right? You didn't keep anything back, right? He wasn't running red lights, stop signs, swerving all over the road, right?
No, but he did a little bit violation. Yes, sir.
Right. We all know he was speeding.
Correct.
That doesn't prove a person is intoxicated, right?
No, sir.
I don't know if you saw your radar in there, but all those people that were, well, when you pulled him over, there was nobody around him. There were a few other cars that passed. Your radar kept going like 77, well over the speed limit.
Yes, sir.
All those people intoxicated just because they're speeding?
No, sir.
Okay. We know that was a traffic violation.
Yes, sir.
Was there anybody that called in, like to 911? There's a drunk driver out there
No, sir.
with respect to Mr. Martinez?
No, sir.
So other than just driving fast, there was nothing else about him driving that indicated to you intoxication?
No, sir.
Okay. When you pulled over, some people who are intoxicated, they keep driving for a long time before they pull over, right?
Yes, sir.
It shows slow reaction time, right?
Yes, sir.
There's nothing about how he acted that showed a slow reaction time. He put his blinker on, he pulled over, right?
Yes, sir.
Nothing about the way he pulled over indicated intoxication, correct?
No, sir, but he did straddle the yellow line.
Yeah, we heard you say that.
Mhm.
Your opinion, because he pulled over to the left instead of the right,
Yes, sir.
that's not how you wanted him to pull over, right?
Let's take it.
Did you get on your bullhorn and say, driver, pull over to the right shoulder?
No, sir.
You could have, right?
Yes, but due to the
Yes.
lanes, say yes, sir.
You could have told him where you wanted him to pull over.
Yes, I could.
But you followed him, you put his blinker on, pulled over to the left, and that's where you stopped him. And then Officer Ponce, was he your corporal at the time?
Yes, sir.
He actually showed up after you and he helped block the scene,
Okay.
block that lane so it was safe.
Yes.
Stop again, because this is a major turning point in the courtroom. The officer just admitted that one of the signs he used against Martinez is not actually listed as a recognized sign in the training guide officers rely on. That is a serious problem. From what we can see, he still presented it to the jury as part of the reason he believed Martinez was intoxicated. Now, the defense has already raised questions about the drinking statement. Then they challenged the driving observations. And now the officer is confirming parts of that problem himself. You can tell the courtroom mood changed because the defense is no longer just questioning small details. They are challenging the foundation of the arrest. But what comes next puts even more pressure on the officer.
He was out on the scene as well.
After the fact, yes, sir.
And he observed Mr. Martinez as well, correct?
Correct.
Now, I don't know how closely you watched the video, but you know that there's more things that you said that are not true when the state asked you questions. Do you know what those are? You have your offense report, and Officer Ponce wrote a supplement, correct?
That's correct.
Okay. And Officer Ponce, he wrote what he observed of Mr. Martinez, right?
Correct.
You stated to the jury that you observed Mr. Martinez chewing gum.
That is correct.
Look through your offense report and point out the place anywhere in there where it says that you observed Mr. Martinez chewing gum.
No, I didn't have it to my report. No, sir.
That's because you didn't notice that. Officer Ponce did. Officer Ponce comes out and he even, so you told the jury, they said, what else did you observe? I observed Mr. Martinez chewing gum. And then that was a sign he was masking, hiding that he was intoxicated.
Yes, sir.
Really? Really?
Yes, sir.
Officer, you didn't even know he had gum in his mouth. Officer Ponce comes out. I mean, eventually you did, because Officer Ponce told you, right?
No, I didn't know it's the chewing gum.
Where is it in your offense report? Show me. Just show me. Where's it on the video that you observed gum in his mouth? Officer Ponce comes out. He asks you, did you watch this part? He asks you, did he have gum in his mouth? And you said, I don't think so.
He's hearsay at that point. He's asking about another person. He's not going to hear.
This goes towards credibility, Judge, what he testified to earlier.
He's asking about somebody else's statement out of court.
I mean, I can ask what happened. That's
a good question.
You weren't, you didn't notice gum in his mouth. The other officer asked you and notified you. He had gum in his mouth, right?
He did advise it. Yes.
Right. And at first you weren't aware. And then Officer Ponce goes up to the car and tells Mr. Martinez, open your mouth, right?
Mhm.
You saw that, right?
Mhm.
And Officer Ponce looks in Mr. Martinez's mouth and he says, spit your gum out. You're not allowed to have gum in a patrol car, right?
Correct.
You didn't have any part of that. If Officer Ponce hadn't even observed it or asked him to open his mouth, you would have never known. But you're here today representing things to the jury that they're totally not true. I mean, I know the gum's an insignificant part, right? I mean, you're not trying to convict a person because he had gum in his mouth for DWI, right?
I'm not trying to make anyone.
You're not. So you're here like testifying in a neutral capacity, or are you biased against Mr. Martinez?
I'm biased, no one.
Unbiased.
I'm biased, no one.
So you're here in a neutral capacity.
I'm here just representing.
Okay, so if the jury, it's who decides whether or not it's guilty or not guilty? You or the jury?
I believe the jury.
Right. When you arrest a person, that doesn't mean that they're guilty of an offense, right?
That's correct.
You just have probable cause. I mean, it sounds like there may be a question about whether you even had probable cause, right?
Just a little review.
Yeah, that's a legal conclusion at that point.
He was earlier making legal conclusions, was he not? Overruled.
I guess my point is that probable cause, you smell alcohol, you pull someone off the road, it's probably a safe thing to do, right?
Yes, sir.
If the jury says they don't think that it was proved in this case, they can say not guilty, right?
That's correct.
And nothing would happen to you professionally in your job if they said not guilty, right?
That's correct.
And since you're neutral and not biased against Mr. Martinez, whatever the jury decides, you would be completely fine with, correct? You said you're not here trying to convict them. If they said not guilty, you should be completely fine with that.
That's correct.
That's correct.
Mhm.
So it's fine for whatever the jury decides, you'll be totally fine with.
That's it. Now, I'm curious as to, was there slurred speech? Were there bloodshot eyes?
Yeah,
I'd like to know about the indicia of intoxication.
That's about where I was going next, Judge.
So,
I'll get there. Sorry. Yep.
get on it, doggone.
This case shows why courtroom details matter so much. A lot of people think if an officer smells alcohol and the driver admits to drinking, the case is already over. But that is not how it works. The state still has to prove the person lost normal control of their body or mind because of alcohol. A smell can explain why someone gets stopped. An admission can raise suspicion. But suspicion alone is not the same as proof. And when the evidence behind an arrest starts falling apart under cross-examination, the whole case can change. That is why this clip stands out. It shows how one careful line of questioning can expose problems the jury may never have noticed. Most people never sit inside a courtroom, but moments like this affect everyone.